There's Mr. Harrison.
Good morning.
How are you today?
Wonderful. Thank you.
Good. And there's Mr. Solario. Okay,
Good morning.
you're up, Mr. Solario.
Thank you, Your Honor. May it please the court. My name is Sam Solario. I represent the appellant, and I'd like to reserve 5 minutes for rebuttal, please.
Sure.
So this is a straightforward case on undisputed legal principles that this court has consistently ratified. Trial courts are legally required to vacate void judgments, judgments that violate due process are void, and judgments that grant unrequested relief or are issued without notice in a hearing violate due process. Appellee is proved unable to defend the orders on appeal under those principles, so she asks the court to needlessly decide a different question altogether, a statutory question under section 48.23 sub 4 concerning the tolling applicable to a lis pendens. The court shouldn't take that detour from the merits. That issue is not properly presented in this appeal, hinges on factual questions the trial court never considered or decided, and is unprincipled as a matter of statutory construction. This court should reverse. I don't want to belabor the facts too much, but I do think the best way to get into the issue is to kind of briefly zoom in on 10 days in January and February 2022.
And Mr. Solario, before you do that, when you read this case, it's overwhelmingly clear that you have two courts handling basically the same case with different claims, same parties, same issue. One has determined the lis pendens is no longer effective. The other one has determined that the lis pendens is. Obviously, that's a problem that you have basically in the same exact case with the same exact facts. You've got one court saying this lis pendens is good, this lis pendens is not good. After that issue, all sorts of irregularities occurred. Strange things happened. But at the end of the day, wasn't there just an effort by the circuit court to be consistent?
I don't think so, Judge Morris, for a couple of reasons. One, I think the one that really stands out, and I don't think this is one you need to decide to decide this case, but I do think it's important, is like, what authority did Judge Huey have to be walking into Judge Barbas's case and sua sponte amending his final judgment? You just cannot run a trial court railroad like that. I mean, it is akin to, a family judge walking into another family judge's case and modifying alimony.
And I understand that, but how would it be if Judge Huey's final resolution of the case says the lis pendens is expired, and Judge Barbas's final resolution of the case says, no, it isn't?
Well, except, and I'm sorry, Your Honor.
No, go ahead.
I understand the question, and 2 points about that. One, Judge Huey never held that the original lis pendens was expired.
The lis pendens.
Yeah, he only held this to the amended. The original one he never said anything about, and there's a reason for that. The appellee never asked him to hold that, and as a consequence, the order he rendered did not hold that. The striking of the protection afforded by the original lis pendens happened for the first time in the case when Judge Huey walked into Judge Barbas's case and entered the second amended judgment, which had the effect of reversing 2 prior judgments: the original judgment, which protected by reference to the original lis pendens, and the first amended judgment, which protected by reference to both the original and the amended.
Excuse me, and let me ask you a question. I'm sorry. Mr. Solario, first of all, just as a clarification, one of the defendants in the foreclosure case was someone named Collar McPhail. Am I correct as I read the complaint? Collar McPhail signed on the note, but was not a mortgagor. Is that correct?
I think that's right, Your Honor. I have to confess, I've not been really focused on the prior note holders. I know that Mr. Charmarthy was the initial note holder, and that there have been some transactions.
And he sued Dees and McPhail, and I think he sued them. He alleged that they executed the note, but he only alleged that Dees gave the mortgage. So I just wanted to be sure I understood the scenario. And the reason I asked that And this was not anything I apologize that had been raised by the parties, but it does go to jurisdiction, so it's not inappropriate for us to examine it. But I have some question about whether even Judge Barbas could have sua sponte entered the second amended final judgment, because when the first amendment, the amended judgment was entered, the court lost jurisdiction of the case with some exceptions, and some, issuing title, considering any challenges to a sale, etc. And also under Rule 1.530, the judge within the rehearing time can, on its own initiative, grant rehearing on the basis that it could grant a rehearing to a party who filed a motion. What happened here, what happened here was that the second amended final judgment granted affirmative relief to a defaulted party, basically.
That's correct.
And I questioned whether even Judge Barbas could have done that, because I don't know that a defaulted party could seek affirmative relief in a motion for rehearing.
But we have a defaulted party here on appeal, so how are they here on appeal?
We have a defaulted party here as an appellee.
Yeah.
Who obtained, who got relief for that, but.
So let me say two things, I think, about that question, part to you, Judge Northcutt, and part to you, Judge Morris. Judge Northcutt, you may well be right about that. That issue has not been briefed, and we were kind of coming in fast in the trial court, so may have overlooked it. But I think if you're right about that, right, the remedy would be to.
If I'm right about that, then this judgment was just absolutely no good, because even no judge could have entered this judgment, correct?
That's correct, and I think the remedy would be to vacate the second amended judgment, return the case to the trial court, and the parties, can be restored to whatever positions they want to take there. Judge Morris, I agree. This is a point we've made in our brief. We don't know what standing Ms. Dees has to be here either. We think that the law is quite clear that once you've defaulted, you've lost your right to defend. And we've cited cases for that proposition in the brief. So, we share the view that Ms. Dees shouldn't even be heard here, but we kind of are where we are.
Mr. Slater, it seems like the three panel members are seeing different issues in this case, or coming at it from three different perspectives. The question I want to pose has to do with what I think is the narrowest issue that's before us, which is, did the trial court err in denying the motion under 1540? And what the trial judge, in this case, Judge Barbas, in this particular order, denied the motion, finding that the appellant had not suffered a due process violation. The concern that I have is, it appears Judge Barbas made that ruling after consulting with Judge Huey, which presumably had Judge Huey arguing or presenting his position why there's nothing wrong. That strikes me as a bit awkward, in that your client did not have the opportunity to argue the due process concern. So it seems to me that's the narrowest issue. If we reverse, that's the narrowest issue we would reverse on. Alternatively, it might be a jurisdictional issue, but one that nobody has argued, and presumably we would need to get supplemental briefing. So am I missing anything in terms of what the narrowest issue that is before us that we need to address?
So I don't want to shoot myself in the foot, but my recollection of the record, Your Honor, is that conversation between Judge Barbas and Judge Huey happened on the initial motion under 540, which alleged fraud, mistake and a need to correct. And there was a discussion about, listen, I need to go talk to Judge Huey and see who ought to decide this. And then Judge Barbas came back and said, I'm going to decide it, and then I'm going to deny the motion. I don't recall that was the case on the motion for rehearing / reconsideration where the due process issue was raised. But when I sit down for my colleague to argue, I'll double check the record and get back to you.
So
in rebuttal.
at best then, if you're correct on that, then we have Judge Barbas denying a due process claim without any opportunity to be heard in argument, but there was the written motion, correct?
Yeah, we had an oral argument on the motion for rehearing directed to the 1.540 where the due process was raised.
Okay, then that was my mistake.
That transcript's in the appendix.
Okay. I think I was looking at that as being the first one and didn't pay enough attention to the date.
Yeah, and when I get back in reply, I can give you the appendix range on the transcript as
Very
well.
good.
Mr. Slarick, can I shift back to the list pendants? I mean, I realize that's a fairly mundane issue compared to the jurisdictional issues and the other issues that we're talking about. The question I have is, when did this list pendants actually expire?
Our contention is that it is not yet expired because of the prior appeals of the disqualification order in Judge Huey's case, the second amended judgment in this case, and this appeal.
So, okay,
Also, there is, if I understand, and we're kind of mixing cases here, obviously, but there's a pending motion to extend that list pendants in what you call the fraud case, what Mr. Harrison calls the loan case.
That is correct, and that's, one of the many issues we think there's no reason. I mean, putting aside, one, we've got an argument that this whole issue about expiration ought to have been raised by cross appeal, that it is functionally a challenge to that portion of Judge Barbas's order that granted rehearing.
But it's possible, like, like if you have an expired list pendants, it's possible for the foreclosure judgment to still give it priority, give that interest priority after the mortgage, the mortgagor's interest. It could, assuming that list pendants could be revived basically by a post-expiration order extending it, correct? So
you're right.
Just because it expired doesn't mean it's not relevant to the interest in the foreclosure case.
You're right for two independent reasons, Judge Northcutt. The first is, as you pointed out, the pending motion to extend the lis pendens, which this court has held trial courts have authority to grant even after expiration. And the second reason is that this paragraphs 5 and 11, which are the relevant provisions of the first judgment and the amended judgment, I think are reasonably read to say that they're not dependent on the life of the lis pendens, that there is an interest based on a legal claim that's being asserted that this judgment is carving out and protecting.
The court is recognizing the potential for an equitable lien, and it's going to give that priority.
That's correct.
Even without a pending motion to extend the list pendens, it could then be filed. So it
could be filed tomorrow.
Correct, and so the foreclosure judgment could take that into account, even if it's expired at this moment.
That's correct, and that's one of the arguments that because of the way this all went down, nobody ever had an opportunity to make. Judge Morris, had I adequately responded to your question?
Well, I think between you and Judge Northcutt, you covered it, because my real issue was, had it expired before any of the post-expiration matters occurred? And at the end of the day, it doesn't sound like it matters. It sounds like there's ways to revive it, and that's what I want clarification on. I think I have it.
Sure. Okay. Well, I don't really want to belabor things other than to say, like, I do think that there are 4 conclusions that you unavoidably walk away with when you look at this record. The first is that on the record, Judge Huey had no reason to know that Judge Barbas was even considering the first amended final judgment. The emergency motion to strike that the appellee filed didn't mention it, and there's no other on the record way in which it would have come to Judge Huey's attention. The second is that Judge Huey was never informed on the record that Judge Barbas rendered the first amended final judgment. Nothing was filed. There were no additional hearings. Third, we know that appellee never made a motion or request on the record that either Judge Huey or Judge Barbas revise the amended judgment. And fourth, whatever process Judge Huey might have followed in making the decision that he needed to revise Judge Barbas's first amended judgment, it was necessarily a process that wasn't invoked by some legally cognizable method of seeking judicial intervention, that was conducted without notice to anyone, and that took place entirely outside of public view. I mean, I think that just really ought to put the due process issue to bed, and I think it's telling that although the appellee expressly encouraged Judge Barbas to deny relief on the theory that, quote, on their due process issue, they got their due process, they got it in Judge Huey's courtroom, close quote, and you'll find that at Appendix 1152 and 58. Their effort to defend that reasoning in this appeal has been kind of lukewarm at best, and that's because the reasoning is just not defensible. I mean, if you imagine an
Larry, let me interject here. We have used your time up to rebuttal time, so proceed as you wish, do what you want with your minutes, but you're at your rebuttal time.
No, I think the court understands the issues, and I'll have a chance to speak to you in rebuttal. Thank you.
Okay, great. Mr. Harrison?
Thank you, Your Honor, and may it please the court, I'm here this morning on behalf of Ms. Dees, whose home is the property that we're talking about in this case. And as the court has already gathered and we've had some discussion on, there are lots of unusual things that happened here between the two courtrooms that have perhaps made this more complicated than it ought to be. But some things are not that complicated here. One of them is this. As of this morning, we are 2 years, 4 months, and 16 days down the road from Judge Huey's order striking the amended lis pendens as invalid. That order's never been challenged, it's never been appealed, it's never been disturbed. And it's not before us today in this appeal.
It still could be reached in an appeal from a final judgment in Judge Huey's case, could it not?
It could, but it hasn't. There was also the ability to take it.
Has there been a final, yeah, well, I know, but has there been a final judgment in that case that was?
No.
So that's still out there.
It's still out there, but as we sit here today, that order stands. If you go do a title search today, that order is recorded and that says the amended lis pendens is gone, it's invalid.
Okay, but let's come back. This is somewhat akin to the discussion we were having during Mr. Solario's presentation. Until the final judgment is entered, Judge Huey could reconsider that ruling and reinstate it, or he could extend the initial lis pendens. So why isn't it appropriate for a foreclosure judgment in another case to give, to acknowledge the existence of that claim and give it priority to the proceeds of the foreclosure sale?
Well, because it's either expired or it's not. And I'm going to explain to you why we believe that it was expired before Judge Huey did anything, which I think is a question that perhaps Judge Silberman raised. But it can't be, again, we can't ever get back to that sort of twilight zone where, as Judge Morris suggested very early on, we have a lis pendens that in Judge Huey's courtroom is invalid, but if I walk down the hallway to Judge Barbas's courtroom is somehow given legal recognition. I disagree. I don't think a final judgment of foreclosure can or should give any preference to an expired lis pendens.
Even though it could be extended thereafter.
Well, it could be, but it hasn't been. And so until it is
even though on an appeal from a judgment in Judge Huey's case, an appellate court could say that he should not have stricken the amended lis pendens.
Well, that That certainly could be a possibility, but
What I'm saying is those issues are not dead.
they're not dead with
And
finality.
they were not dead when Judge Barbas entered his amended foreclosure judgment, or initial foreclosure judgment for that matter.
The initial foreclosure judgment, I don't think referenced the lis pendens because it hadn't been filed yet, because that predated that case. The first amended foreclosure judgment referenced the original lis pendens. We believe, it is our view, and I'll explain it here in a moment, that the original lis pendens expired in December 21 before Judge Huey ever saw our motion or did anything or reached out to the other case or any of these sort of unusual things that occurred. And if that is correct, if it expired before Judge Huey did any of this stuff, then it's got no place being referred to in the foreclosure judgment. The fact that you may do something down,
I mean, do you have authority for that?
I don't. But
Mr. Harrison,
I mean,
let me-
this case is plagued by a lack of authority for a lot of what's happening.
well, it is. It absolutely is, because I think it's an extraordinarily unusual scenario.
Mr. Harrison, a notice of lis pendens could expire as a matter of law. However, the question that I think we're all struggling with, or at least I am, is Judge Huey never made that finding, correct?
Correct.
Judge Barbas never made that finding. Is that correct?
Yes, he made no finding on that.
Okay. So if neither of them made the finding, yet Judge Huey's what I'll call the second amended judgment in the foreclosure case, if it strikes the language that made some reference to the first lis pendens, as well as the claim for equitable lien, how does that comport with due process? When nobody, again, there may have been an expiration as a matter of law. Nobody has ruled on it. And essentially what I think you're asking us to do is make a determination that in fact, as a matter of law, the first lis pendens expired, therefore no harm, no foul.
Well, yes, you're right. That's exactly what we would like you to do. Let me clarify one thing before I answer your question, because this has come up more than once. The first amended foreclosure judgment and the second amended foreclosure judgment both refer explicitly to the notice of lis pendens filed on such and such a date. And then the second amended refers in addition to the amended notice. None of those judgments has generic language about Ms. Davidson's equitable claims or equitable lien. It is entirely a function of the notice of lis pendens. So,
yet Judge Barbas in the original final judgment included that language of protection based on the idea that there may be an equitable lien and a right for the appellant to pursue. And I don't want to lose sight of the fact that if a lis pendens has expired, that's a title company issue. It isn't necessarily a judicial issue unless someone asks the court to clarify the public records. And so you do have Judge Huey purportedly clarifying the public records when nobody asked him to. So if you are correct that the original notice of lis pendens expired, why would we address that in the first instance when you can go to any title company and say, it's expired, it's gone? Even if we were to reverse the second amended judgment, you're still left with the first amended or the original amended judgment. And then you go to a title company and say, by the way, there's no lis pendens, it's gone as a matter of law. Now they may not buy it, and we know that title companies are hesitant to buy it. But if you want that cleared up, isn't it your client's burden to ask a court to make a definitive determination that the first lis pendens expired?
well, again, this is part of the unusual things that happened in this case. And let me back up. When we went to Judge Huey with our emergency motion to strike the amended notice of lis pendens, we pointed out in that motion that the original lis pendens was filed in December of 20. It has since expired. We made that claim in the motion. We didn't ask him to rule on it because I don't think you need a finding. What you need is a calendar, right? And we also,
well, but that goes exactly to my point, which is you don't need a ruling, and yet he made a ruling on an issue that was not squarely presented to him, either in the fraud case or the foreclosure case. You know, neither one did he make a specific ruling that, yes, you are correct. The notice of lis pendens is gone. And what you just said is the point that I'm making, which is a title company can look at the calendar and make the same determination. So why would we uphold a judge's determination that was never really presented to the court?
well, I don't think it's a matter of upholding that determination. And I don't think Judge Huey made a ruling. Again, there's a little bit of a mystery here because nobody knows, and it's not in the record. And we just don't know what prompted Judge Huey to, one, grant our emergency motion, which he did, but then two, take the next step on his own. Nobody asked him to do this. My client didn't ask him to do it. He, on his own, then went down a hall, metaphysically speaking, and said, well, let me fix the foreclosure because it's got to be the same. It can't be a lis pendens in one courtroom, but not in the other.
And his motivation may have been a good motivation, but that's not how courts work, right? There's an opportunity, if he's going to go beyond what he ordered in the fraud case, isn't there supposed to be an opportunity to be heard on what language is going to survive or not survive in a case in which he has no involvement?
Well, again, Judge Barbas, in the ruling that is before you, said there was due process in Judge Huey's courtroom.
Well, you know, how would he know? How would he know? I mean, because, you know, the facts that we have in front of us doesn't sound much like due process. But regardless, what difference did it make to Judge Huey's tort case? What was in Judge Barbas's foreclosure judgment? I mean, what possible motivation did he have that one could describe as judicial?
Well, again, I don't know what motivated him other than, I think, rightly so, the need for consistency. I cannot imagine.
Why? What does he care? He is overseeing an intentional tort action. He doesn't need consistency with the foreclosure judgment.
Well, but he was aware of the foreclosure judgment because of the cross-pollination in the cases. He's just made a ruling on the amended lis pendens. So
and decided on his own that he ought to go.
Right. I assume that he thought he was doing somebody a favor.
I don't think he's done anybody a favor, to tell you the truth.
Well, no. Here we are, you know, on I think our third appeal in this case,
right.
With many months and years actually down the road. But before I run out of time, let me make my pitch, because we keep talking about it, that the original lis pendens expired. It's briefed. The only possible appellate action that could have stopped the running of the 1-year life of that lis pendens was Davidson's certiorari review, which I think later got converted to a non-final appeal. But in any event, the appeal of the order disqualifying her previous counsel. And so when we look at the lis pendens statute, it is case specific. Everything in the statute talks about an action or the action. And then we get to this provision at the end that says, aha, that 1-year life up in section 2 doesn't run during the pendency of any action in an appellate court. Very broad language. We know, because this court has said, as have others, that word any in statutes is linguistically ambiguous. We don't necessarily take it literally. We have to give it its proper context. So here the question is, why should an interlocutory appeal on a purely collateral issue, disqualifying a counsel, that didn't even result in a stay of the underlying case? That case kept moving along because no stay was ever granted. why should that appellate proceeding in any way serve to lengthen the duration of the 1-year lis pendens? It doesn't have anything to do with the property, has nothing to do with the title, has nothing to do with any interest or claim to the property. And so we think that that is not the type of appellate proceeding contemplated under the lis pendens statute that ought to extend the life of the lis pendens. And if that's correct, that means the original lis pendens expired in December of 21 before Judge Huey did anything. And we think that gets you to a place where we have to ask, is this case moot? If the original lis pendens already expired, then taking it out of a foreclosure judgment, as I think it was Judge Silberman put it, is no harm, no foul. Nobody is entitled to the protection of a lis pendens that's expired. I mean, it has an expiration date for a reason. And so that's where I think we end up. Again, you know, my client didn't do anything to cause any of this. This was all the direct result of Davidson's disqualified lawyers taking it upon themselves to interject this amended lis pendens that they had no.
Are you raising the correctness of that ruling in front of this court now? Because I can tell you what, I have some serious concerns about whether Judge Huey was correct to strike an amended, to strike a lis pendens filed by attorneys, because it's not filed in the action, it is recorded in the public records. And one could argue that Ms. Davidson had the perfect right to have those attorneys record that amended lis pendens regardless of whether they had been disqualified from the litigation.
Well,
so I mean, if you want to inject that issue in this appeal, you know, I'll be real careful.
well, I don't know that I have the ability to inject it in this appeal because
Well, you've been arguing it in front of us today.
But I will say this, what the disqualified lawyers did was they filed the amended lis pendens through the e-portal. They filed it in the case like you file a pleading.
So what? So what? Yeah, the lis pendens is recorded in the public records and it refers to a case. And, you know, you give a notice in the court file, but you know, Ms. Davidson, if she had the right to have an amended lis pendens, you know, was it correct for the judge to deprive her of that because of her attorneys who were not participated to litigate, that those attorneys filed it on her behalf? I mean,
well, I don't think that's why.
That would be a very good question when that case gets to appeal.
But let's be clear. Judge Huey's order doesn't say I'm striking the amended lis pendens because they weren't authorized to file it.
Why did he do it?
We argued both.
You filed the motion. What was the motion about?
The motion was, one, they're disqualified. They don't have any authority to do it. But two, there's no such thing as an amended lis pendens. That's not how you extend the 1-year life of the lis pendens. And we don't know which of those Judge Huey ultimately agreed with, but he clearly agreed with one of them at least. But no, we've got enough bizarre, convoluted things in this case already. I would like to not bring another one into the mix. This is certainly a challenging record. And unless there are questions, that's what I have. I suspect I'm about out of time anyway.
Can I ask you one thing to clarify with the question I asked Mrs. Solario? Am I correct? Collar McPhail did not have an ownership interest in the house, but signed on the note?
I do not. Well, he had an ownership interest in the home jointly with Ms. Dees at one point. They were married, and then somewhere along the way, he quit-claimed his interest. I cannot.
May have had a homestead interest, but
yeah, so
was not on the title, I don't think.
I know that Mr. McPhail never participated in any of these proceedings below and was not represented in any of these proceedings below.
Okay, great. Thanks, Mr. Harrison. Nothing else from you today. All right, Mr. Solario, you're up for rebuttal.
Yep. So I've got a couple of points I want to make, but I want to deal with some record issues first. One, I heard Mr. Harrison to say that Judge Barbas's original final judgment didn't contain the protections under the original Liz
I know,
Pendens.
it did. He had his original and amended mixed up. The original did. His amended protected both, and then the second amended eliminated both.
That is correct.
Hmm.
Okay, so the second record issue was I heard Mr. Harrison to say that Judge Huey was aware of the foreclosure judgment. The only thing I see in the record, and this is at page 706, paragraph 12, is in the emergency motion where Mr. Harrison's client tells Judge Huey, hey, there's a foreclosure judgment. What I don't see that Judge Huey had any reason to know about was what the content of that judgment was, or that Judge Barbas was at that point presented with a proposed amendment to the final judgment that referenced this amended Liz Pendens. So I don't know how on this record Judge Huey had any idea that there was something in Judge Barbas's case he needed to fix. Third, Judge Silberman, with respect to your questions, the transcript of the hearing on the motion for rehearing on 1.540 is at 1137 through 67 of the appendix. What Judge Huey does at the end, and this is Judge Barbas does at the end, and this is at 1162 to 63, is take it under advisement. And basically, I'm going to go look at what Judge Huey decided. It was on the first initial motion, the one that raised fraud and mistake, that Judge Barbas went and talked to Judge Huey, and you'll see that at page 1100. I think the headline on the merits is that if the appellee had a problem with the contents of Judge Barbas's foreclosure judgment, either the original or the first amended, the remedy was a motion for rehearing, a Rule 1.150 or 540 motion, or an appeal to this court. She didn't take any of those steps. The remedy was not to resort to self-help and complain to Judge Huey about something that had been filed in the case. Like, that's not the way to resolve the problem. And the fix was not for Judge Huey, without giving anybody notice and an opportunity to be heard, to make that amendment. I want to talk a little bit about the expiration issue. One, I do just want to emphasize that the resolution of that issue is not merely contingent on what the trial court might find as to what are the dates that this thing was told. It is also contingent on what the trial court might find with respect to what its foreclosure judgments mean. Do they adopt Mr. Harrison's interpretation or my own? And also contingent on the outcome of the motion to extend, which hasn't been decided. So I think you've got three layers of predicate determinations that would have to be made before you could say that the mootness argument, as Mr. Harrison characterizes it, is an alternative basis to resolve the case. And I think that highlights why I think you should bite on our cross appeal argument, because if this thing had been raised by cross appeal, you would have had an opportunity to see this all kind of thoroughly briefed out in an initial brief, answer brief, and a reply. As it stands, we got the back half of a 4,000-word reply to kind of address a statutory question of first impression. And on that point, I do just want to highlight that I think the most natural reading of any action in any appellate court is to say that time is told by any appeal in the case in which the Liz Pendens is asserted, or that has a bearing on the validity or effect of the Liz Pendens.
Well, in that respect, you acknowledge that the cert petition really had no, as a cert petition, didn't really have any effect on the jurisdiction below. As a non-final appeal, it deprived the lower court of the jurisdiction to enter a final order in the case, correct?
That's correct, but I think a couple of other points I would make about that. One, that appeal was taken in the fraud case in which the Liz Pendens was connected to. Two, I just think as a matter of statutory interpretation, if you look at sub 1 and sub 2, what they're really saying is, when does a Liz Pendens operate to kind of secure a claim with respect to real property? Sub 2 talks about the period when the Liz Pendens is effectual. And, you know, it just kind of makes sense, given the legislature's use of the indefinite article any twice, that it would have contemplated, hey, appeals at any point in the case where the lis pendens is asserted have at least the possibility to prompt delay. That didn't happen in this case, but it could happen in any number of cases. You could have a stay of proceedings, you could have, you know, parties just want to wait out and get a decision on the appeal before they move forward, such that the thing would remain effective during the pendency of the appeal. And I would just point out, I think Mr. Harrison's interpretation, which as I gather is it's only told during the period of an appeal from an order that determines the validity of the underlying claim. That's just inconsistent with the text the legislature used. It used any twice. If it had meant to limit the statute to a single category of appeals, essentially a final judgment appeal in the underlying action, it certainly would have used more specific language.
Okay.
I think I'm probably about out of time.
Yeah, you are. Thank you both very much for this. Well, I wouldn't really thank you for this interesting case, but anyway, thank you for your presentations. In order to leave our virtual courtroom, you need to click the leave button, which I think is in the current version.